Let me give you a simple hypothetical situation. A man and his wife living in Dallas, both, say, 70 years of age, have a sizable amount of money in a local commercial bank. They have six grown children. He does not have a will, and he suddenly dies. My question is, who gets the money?
Now, if they just have this money on deposit in a checking account, if this is community property, the the survivor gets half or has half as his or her community share. I believe you said the husband
The
dies.
husband dies.
The widow would have half, and the children would have the other half. Now, this is the normal rule of inheritance of community property.
In other words, the wife would not automatically get all of that money.
That's correct. Now, if they have put it in a savings account and have simply designated it by a signature card as a joint tenancy with a right of survivorship in an ordinary savings account in a commercial bank, I believe the result would be that it is not a joint tenancy with right of survivorship because they have not gone about it in the right way to transform it into a joint tenancy. Hence, it would still be community property, and the six children would take their half.
The same 70-year-old man had wanted to avoid that. Namely, he wanted his wife to get all of the money in the savings account and in their checking account. How could he have guaranteed that this would have happened at his death?
Well, the easy way to do it, of course, Ron, is for him to make a will to that effect. Or he and his wife can divide the community property into two separate shares of separate property and then recombine it as a joint tenancy with right of survivorship. They would, of course, have to consult a lawyer unless they're well trained in law. I should, though, further mention that if they have the money deposited in a savings and loan association, the savings and loan statute indicates that that would constitute a division, and hence that would be a true joint tenancy with right of survivorship. Now, the provision in the Savings and Loan Association Act has never been before the courts, but that would be the way I would construe it. It's conceivable, of course, that statute might be construed as being of general application to cover those savings accounts in ordinary commercial banks.